Now we're going to take a look at another case study, and we're going to really dive into this one in much more detail. This case study looks at the legal consequences of terminology mistakes in a fuel directive, so in a regulation from the European Union. This case study is based upon a paper by Jody Byrne called Caveat Translator: Understanding the Legal Consequences of Errors in Professional Translation. And this study explores the legal consequences of terminology mismanagement, again, in the field of fuel directives. So we're looking at terminology problems with materials that describe material and how to handle a material that is highly flammable, very dangerous. Products that represent a danger to human safety, if mismanaged, like fuel, are required to use safety signal words in any instruction per U.S. regulations. These signal words have the following stipulative definitions. Danger. Use danger for imminent hazards, which, if not avoided, will result in death or serious injury. So this is for extreme situations. Warning. Use the word warning for potentially hazardous situations that, if not avoided, could result in death or serious injury. Caution. Use the word caution for potentially hazardous situations that may result in minor or moderate injury. And finally, notice. Use notice to state company policy directly or indirectly related to the safety of personnel or protection of property. Do not use in place of a hazardous message. It must be noted that while these safety signal words have standard translations, the regulations that require the use of signal words are only applicable in the United States. That is, these terms can be translated in user manuals and other materials, but the regulations behind the terms are not enforceable outside of the United States. This is where localization is important, where if another country has their own system for signaling dangerous situations, their terminology should be followed, and the terminology from the U.S. environment should be replaced with that. Byrne's paper describes a mistranslation of the word fuel in an early version of European Council Directive 70/220/EEC, Technical and Safety Requirements for Vehicle Fuel Tanks. The term fuel in the English source was translated as Benzin in German rather than Kraftstoff, where Benzin means petrol and Kraftstoff means fuel. You can see the English here. Provision must be made to prevent excess evaporative emissions, and fuel spillage caused by a missing fuel filler cap. And you see the German translation below. Byrne notes that Benzin was requested to be changed to Kraftstoff on the grounds that the existing wording was causing misinterpretations. That is, there was an issue with false equivalency in that a type of fuel, petrol, was used as the translation for the superordinate concept of fuel. This mistranslation relating to the extremely flammable substance of fuel, if not detected, would have had the following impacts per Byrne. The impact for target users would have been such misinterpretations could be dangerous and possibly even fatal for target users. The impact for regulators per Byrne, this error would have seriously affected the ability of the directive to regulate, standardize, and govern the manufacture of vehicle fuel tanks by effectively creating a very large loophole in the requirements. The impact for manufacturers, it would have been very costly per Byrne if a manufacturer designed a diesel tank having taken into consideration the misleading provisions contained in the translation, and the tank subsequently needed to be recalled, redesigned, and retrofitted with a cap. A European Commission, abbreviated EC, declaration of conformity is required by the European Union for any product or good sold within that territory. Failure to provide a complete and accurate translation of a user manual renders the CE declaration void, since the European Union considers instructions to be a part of the product that is being imported into that territory. Errors in a translation therefore render an entire product defective per the European Union, and defective products are not permitted to be entered into the European Union if the defect is discovered during customs. If later discovered, defective products can be pulled from markets. According to EU Resolution C411, having translated instructions is not enough. Documentation must be clear, it must be accurate, and it must be easily comprehensible. According to Byrne, technical product documentation must be tailored to the specific needs of the intended audience, and it must help them to perform whatever tasks they need to perform in order to use the product correctly and safely. Naturally, this also applies to translations. In certain circumstances, this may involve quite significant changes to the translated text in order to comply with target audience expectations, conventions, customs, and to reflect the physical and technical landscape in which the product is to be used. For example, if different voltage systems need to be used, different waste disposal laws are in effect, or if climate conditions require changes as well. Such provisions for liability owing to faulty or incomplete documentation have been incorporated into the laws of most, if not all, European member states. One such example is Germany's product liability law, which also regulates documentation as an integral part of the product and entitles users to replacement and/or compensation if the documentation results in damage or loss. This again being quoted directly from the Jody Byrne article. A study conducted by the German computer magazine Computer Bild in 1996 revealed that the majority of user guides for electronic consumer goods were defective in one form or another, and users would have been entitled to such compensation based on that law. So you can see a short list here pulled directly, once again, from the Jody Byrne article of directives requiring usable translations in order to promote understanding and the ease of safe use of products use of safe products imported into the European Union. You've got several examples here. The General Product Safety Directive, which states that there must be clear warnings in the language of the country in which the product is sold. A directive on medical devices that states that documentation must be translated, must anticipate potential reasonably foreseeable risks, and describe precautions to present those risks. Another directive on in vitro diagnostic medical devices that says that documentation must be translated and that the translations must be accurate, easily understood, and applied by the user. You can pause the video to read through the rest of the example regulations if you wish. The slides for this presentation are also provided to you if you'd prefer to read through these examples in PDF format. And I'd encourage you as well to think about the markets in which you will be operating as a localization manager. You'll need to be aware of the regulations around importing products, around ensuring consumer safety when translating and dealing with terminology in specific markets for specific domains. Remember the overall goals of technical communication as well: clear, efficient communication that avoids ambiguity. This is written into the laws of the European Union, and the reason this is written into the laws is to protect consumer safety.